All right. Well, welcome everybody. Now they say that no field is a serious field unless it's got lawyers lawyering, and I think that's a sort of a cynical take, but I think there's something to it. Now the oddity in this case is there are lawyers trying to lawyer in this field. As someone who was in charge of strategic planning for one of the leading legal firms in DC pointed out to me, it's a growth field. He said cyber was the other one, and I thought, oh, they're hoping to get cases and litigate, and they're trying to get smart. I think that is going on. However, um, there aren't many cases or any cases, and we'll learn more about that. So the good news is the lawyers want in and have been in a little. They think there'll be more lawyering to be done, but we're on the ground floor of whatever that new spike in demand will be. And I think that's important, and I'll tell you why. Uh, First, from a national security standpoint, we do have adversaries. We used to call them enemies, but now we can't quite bring ourselves to say that word. But they could become enemies. Enemies are people who you fight in a war. And in that regard, certainly taking a look at the North Koreans, Iranians, Chinese, and Russians, uh, it's very common to hear hawkish people say they don't follow the rules. Well, actually, even dovish people will point this out occasionally. They don't follow the rules. They don't honor the law. And people think, oh, well, they don't care about the law. That's not quite right. They care a lot about the law, and they actually are pretty good students of it, arguably better than we are, or at least as good.
Correct.
And what they do is they try to find the seams where there's ambiguity, and they like to operate there. I mean, a good example maybe would be hypersonics. Do those things orbit or not? Are they covered by the space treaty? Uh, high altitude balloons at some point become an interesting example. Is that is that covered? Does that violate someone's air sovereignty, or is that a near space? At what point?
No,
Well, okay.
it's
I'm just
air.
telling you. Please restrain yourselves. We have three lawyers, and I'm hoping they will disagree with one another. You can see they're chomping at the bits to tell you what they think. So I think it's important and fun. Uh, Not that we should ignore things if they're just important, but it's okay if something's fun too. Um, to listen to different views about what few laws there are, how they might be applied or not applied, because we can learn something about how others might take advantage of that. And then finally, in the area of commercial, there's just an awful lot of property that's going to be flying around up there. And the idea that capital that is large in its value would be unencumbered and not protected by law seems un-American uh, to me. I mean, it's just somehow the whole purpose of our country is to somehow protect capital at some level, at least my capital, and therefore everyone's capital. Um, with that as a kind of drum roll, we have three people here who I think we're going to really give us, I hope, a little bit of a headache, and that's what we hope for. I guess, have you, I mean, I think the order of battle should be Henry Hertzfeld first, followed by Jack Beard, and then Laura Montgomery. But do you
Well,
folks, as presenters, have strong views on this?
we worked it out ahead of
Yeah.
time. Henry can go first, then Laura next, and I'll go last.
Okay. Well, now, because there are three of you, I'm going to ask you to do something which many lawyers have a very difficult time with. and that is their watch. If you don't have one, we can supply one virtually. Control yourself. What is the time limit that we want? I think what I would propose we do is this: no more than 15 to 20 minutes, and I mean no more. Because what I think we'll do is we'll allow 5 minutes of Q&A after each presentation, and then open it up for Q&A for all three. Does that make sense? You speak up now.
Yeah, it's fine.
Okay.
can do
I
that.
think, yes. Now, let me just do one courtesy here. You should have the bios, but I think the attraction of these folks is that they come from slightly different backgrounds, but they are all focused on space and space law to varying degrees, and therefore we're really lucky to have all three. Now, Henry Hertzfeld is at the Elliott School of Public at George Washington
International Affairs.
International Affairs.
Yeah.
And he served as the director of space policy. That would be roughly Scott Pace's current job. Am I right?
Correct.
Yeah. Well, so there's more than law in this man. He's got space there as well, and he has government service. I always like to see government service when I listen to people talk about public policy. Senior economist, both at NASA and the National Science Foundation, and he is well written, and of course teaches courses in space law and economics. So he's going to give us kind of a tour of the horizon, I think, roughly. And why don't we hand it over to him now, and then I'll introduce the other two as we get to them. So over to you.
Okay. Well, thanks, Henry. Obviously, in 15 minutes, I can't cover a 2-hour lecture in class, but we'll try to give a few highlights, and I'll start with just, are my slides up, by the way? Okay, go to the next slide, please. Okay, I'm going to start with just some general views and general points about space law and where it fits. And then I hope we'll have time to at least review the principles of the Outer Space Treaty and allude to some of the various points within. But in spite of Henry saying that there isn't much space law, these treaties have been around for over 50 years. Yes, we have a lot of discussion, a lot of ambiguity. They're really a set of principles. But anyway, just in general terms, I'm going to also speak mainly on the civil and commercial side because both Jack and Laura have done a little more on the military side, and we'll address that a little more closely in their comments. But keep in mind as we go through this that almost everything we do in space is dual use. And so a lot of things that we'll talk about overlap both civil and security issues. So anyway, all space programs have legal implications. We have to start there. And some on the top of our heads these days are NASA's going to back to the moon with the Artemis program, and of course deeper space exploration, Mars and beyond. And in anticipation of the moon, and to encourage international participation particularly among nations that want to work with us, NASA developed the Artemis Accords. They are non-binding. These are not treaties, but they're agreements with other nations, and they're basically nothing new. There is basically nothing new in there. It is They are primarily a restatement of the principles we'll talk about in a few minutes of the Outer Space Treaty, but they have also some implications for working with resources, governments working with resources in space and on the moon, and also safety and particularly safety zones have been introduced as a possibility to work out when we actually get there. So, excuse me. There are still a lot of open questions because space is non-sovereign by definition. What do we do when we get to the moon? And others are there as well. And also with orbits and in other examples, what you put into space is your property, or so that we have property rights in space. But when it comes to resources up there and using parts of space for research and or for profit, there are questions that have not been fully solved in the law yet. There are issues of sustainability in space. A couple of years in 2019, the UN COPUOS, Committee on Peaceful Uses of Outer Space, passed 21 points on long-term sustainability. In other words, let's not mess it up so that we can still use space in the future. But we've got a lot of issues underneath that general term. We were putting up a lot of small satellites in low Earth orbit, in constellations, and it's going to get crowded up there. And crowds, of course, mean added risks, whether it's debris from accidents or just a lot of small satellites that are getting in each other's way, or even in geo orbit, skipping a bit, we have spectrum issues. That's been handled pretty well by the ITU and international negotiations, but we're just starting with crowding up low Earth orbit, so there are issues there. Technology has changed, and we also have the ability now to go to other satellites and to even service them, fix them, put new engines on them. The MEV, Northrop Grumman's vehicles, has shown that commercially they can do that. RPO stands for Rendezvous and Proximity Operations. But, if we can do it, others can do it too. And if you can approach other satellites in space, there are obvious risks of security and other things up there that have to be dealt with in a far more systematic way, legal way than we have yet, even though we have rules. The anti-satellite testing, the U.S. did last year come out with a new norm. It's that we will not engage in those types of tests. Other nations have done it before. We did it many years ago, and the Russians too. All it does, though, is create a lot of debris. And so that we've said we won't do that in terms of testing. And the norm is worth more discussion than that because it is really full of loopholes, but at least we've come out and said something that works toward a more peaceful use of outer space, which is one of the basic principles of the treaties. And of course, the debris issue I mentioned very briefly, but removing debris is, of course, has risks in and of itself. Technically, we haven't really done that yet, but we're going to have rules we already have some about deorbiting and about not messing up the conditions in space more. Hopefully not too much more debris than we have up there now, but that may be hard to avoid. Then we have companies working in space, private companies. We license them in the US through various agencies, depending on what they're going to do in space. But all the regulatory agencies really are aimed toward controlling, making it safer, and working with industry, not only to encourage it, but to encourage safety in space. And of course, there are tensions there. How far do you go? What is costly? How do we compete with other nations and their companies and things of questions of that sort? I threw in planetary defense. It gets some newspaper headlines. It's basically trying to protect the Earth from that big asteroid coming in some time, 200 years or more out there. But we do have meteorites. We do have things hitting the Earth anyway. It's not a hypothetical risk. We have evidence that it's happened before. Can we, with our technology, protect the Earth in the future? Open question, and again raises some legal issues. Next slide, please. So behind all those types of missions we have in the trees, what is the responsibility of a nation under the space treaties? Article 6 of the Outer Space Treaty says states are internationally responsible. Article 7 says internationally liable. What does all that mean? There's still a lot of discussion there. There are words in Article 6 that the nation is under an obligation to authorize and continually supervise not only its own activities in space, but those of its non-governmental entities, which means industry, basically. But defining how much supervision, what type of supervision, is quite open in the discussion. We don't have any specific rules on that. And how do you regulate the satellite servicing, the small sats? I've already talked about that a bit. I won't repeat it. Liability is a very complicated issue. Again, we have simple rules in the Liability Convention that say that if something comes back down from space and hits the Earth, there's absolute liability. The company somebody would have to pay, and the state is responsible. And if there's an accident in space, it's based on fault, but you've got to get evidence to prove that. And we don't have a definition of fault. We don't have good evidence of what's happening, what might have happened in space. Also, liability is, interestingly, in Article 7, unconditional, unlimited in time or amounts. And the conditions are that the launching state, according to the Liability Convention, is responsible for payment. So the state can then transfer some of that responsibility through its licensing and make companies liable up to a certain amount. We do that in the United States, is up to a maximum of 500 million. And then the government has said it will indemnify above that up to an inflation-adjusted $1999 of $1.5 billion. Laura wrote those initial rules a long time ago, but they're still there. And other nations have different amounts and different rules. Liability is a complicated topic in space. Who owns the moon? We've said that space is non-sovereign, so that essentially it's not owned. Can we still land there? Can others land there? How do you divide it up? Can you use it? Did I hear? Oh, okay. I'm sorry. And then we don't even have a good system for settling disputes in space. Those treaties are written by nations, for nations, and it calls for diplomatic negotiations. That's basically it. How do we, if we have disputes in space, and particularly if private companies are involved, it raises a lot of questions looking to the future. Next slide, please. Okay, we haven't even gotten to the principles of the Outer Space Treaty, so I'm going to skip a few slides here so that I only have about 5 minutes left. So let's go to the next slide. Space law exists. Some people will say, no, it's the Wild West, but we do have at least a format for space law in the treaties. Continue on, please. Next. Okay. First of all, the preamble of the United States to the NASA Act of 1958, the act that set up the agency, starts out saying the United States is going to use space for peaceful purposes and benefits to all mankind. Those words are found in the UN treaties later as well. There are some earlier resolutions, but I think we always say the Outer Space Treaty or OST, but it's important, I think, to read the third sentence there. That is the actual title of the treaty, is a treaty on principles governing the activities of states in the exploration and use of outer space, including the moon and other celestial bodies. The moon, therefore, is a celestial body according to the treaties. But it is a treaty not on outer space itself. It's a treaty on how we, through our nations, explore and use outer space. And I listed really the 5-6 principles here. I mentioned peaceful purposes. International cooperation is encouraged in the treaty. There's the freedom of access and exploration without discrimination. No sovereignty, as I mentioned. No state may actually appropriate anything in space by declaring sovereignty or by any other means of use, according to the treaty. And then the state responsibility I mentioned. And then importantly, the one specific no in space is no weapons of mass destruction be placed in orbit or on celestial bodies. Note that does not prohibit a launching through space of a weapon of mass destruction, a nuclear weapon specifically, and it does not specifically prohibit weapons in space, although using them would probably be a violation of the peaceful purposes. And there you get into a discussion of what is peaceful and what isn't. Next slide, please. Okay, I think it's important to say and remember that there are analogies to treaties here on Earth. Around the same time as the Space Treaty was negotiated in late 1960s, the Antarctica treaties came out of the International Geophysical Year, and not too long after the UN Convention on the Law of the Seas. Also, you'll see similar wording in all of those treaties. I say similar, not exact. So that there are analogies, but not always 100% applicable. Next, please. I know Henry was talking about the balloons and other things. Where does space begin? It's usually defined as the edge of the atmosphere. It's roughly 100 kilometers up there, but we see all sorts of definitions of where space begins. I saw one in the paper the other day. Virgin Galactic just went up, took some tourists up into space, I think some employees yesterday, and they got to 54 miles up, not 62, which was about 100 kilometers. And they consider that they're in outer space. But commercial companies want to make it lower so they can give rewards to passengers. That's fine. But generally, it's much higher than that. And there's still gray area there. It raises other legal questions. If there's an incident around the edge of space, are we in national space or are we in outer space with the treaties? If you're over a nation and the nation is considers that national space that they regulate, the rules could be very different. Next, please. Okay, again, these next two slides, this one quickly. Where does this law come from? Is it the UN, international organizations, military? Is there no law? It's none of those, really, because the treaties are not self-enforcing. Nations have to pass laws to meet their obligations under the treaties. Next, please. Space law, as I said, comes from some of the 1958 International Geophysical Year negotiations, but it comes from other places too. Defense security agreements, it is telecom, as the ITU convention, the nuclear security non-proliferation, regimes, and other precedents. But even more importantly, these treaties are specifically tied to the UN Charter and general international law. And those are words that are used in the treaties themselves. So we have a broader set of rules as well as the specific ones for space. Next, please. Okay, skip this slide. We don't. My time is almost up. I'm watching the clock. Next, please. The next one, yeah. They're written by. They've been written a long time ago when COPUOS was small, and in the roughly late 1960s, early 1970s. Next slide. Okay, there are 5 treaties that make up the system of space treaties, specific system of space treaties. The United States has ratified 4. The Moon Agreement, as you can see below, has only been ratified by 18 nations, signed by 4. It's considered a failed treaty, yet it's still, we don't have time to discuss it right now, interesting in and of itself. But the basic ones that we adhere to and we have obligations under the Outer Space Treaty, which is the master document, a little more on the detail in the other treaties. The rescue and return is has never really been invoked except the return of parts that have fallen to the earth. But it's not that controversial. Liability is, I mentioned, it's a subject of, again, another long conversation. And then the Registration Convention builds on Article 8 of the Outer Space Treaty that says a nation should keep its registry of what it has launched and then submit that to the United Nations so the world knows what has been launched. Originally, the idea of the Registration Convention was to prevent accidents so that people would know where things are in space. It's not been too successful in doing that, but it has other important uses in identification and who to contact if something happens in space, as well as perhaps some other. It's been used very importantly in the ISS, the International Space Station Agreement. All the partners of that agreement have to register their components of the International Space Station. And that also has implications for everything from intellectual property to how nations act on the station and identify their units separate from the entire complex that's up there. It is also that type of cooperation is likely to be repeated with the Artemis Accords with our partners when we go to the moon. In one form or another, it would be based on that. So my time is up. I was going to go into some of the other details of the Outer Space Treaty. As you can see, there's a lot to be said, but I'd be glad to take any questions and try to answer them later. I wanted to get at least this far and give you at least an appreciation of where we are with the treaties. Thanks.
Okay. Well, I think it is somewhat frustrating. There's a whole course behind that lecture. It's not just
Yeah.
a longer lecture. But I think that the function of this course ultimately is to frustrate you into wanting to do something which is very seditious. Read. And, I'm not sure we're cut out for that, but if we do that, there are readings that Professor Hertzfeld has, recommended that we take a look at, and it will help fill out much of what he was not able to, orally present.
Let me add, Henry, that to also read the treaties.
That's
I
that's
have
very
there,
seditious.
I know. I mean, they're not that long. I've read them many times, and every time I look at them, you see different things. You see a comma here or a word there that you hadn't noticed before, and if you really stop and think about it, there's an awful lot to um, to look at when you go through the treaties themselves.
Well, I am guilty of only having read this Outer Space Treaty once, but I've got to believe you're right, because I do read the Non-Proliferation Treaty, Nuclear Non-Proliferation Treaty, at least 2 or 3 times a year, and exactly the same thing happens that you
Yeah.
describe. You go, "Oh my God, I haven't thought about that. What has anyone else?" And you scramble and you discover half the time, well, no one else has either.
Yeah.
Uh, so it's fruitful to just take a look at these short documents and see what they say, instead of reading secondary explanations of what they might mean. So, in that spirit, we're going to move to our next speaker, Laura Montgomery, who is a professor of space law at Catholic University and has her own little nonprofit protected by a limited liability company, no less, Ground Based Space Matters. Now, she has a background in space regulatory law, having worked at the FAA, Federal Aviation Aeronautics. Well, FAA stands for Federal
Aviation
Aviation
Administration.
Administration,
Yeah.
but despite its aeronautic character, it has an aerospace component, and we know this because Miss Montgomery was served as the manager of the space law branch there for many years, and so she comes to this with hands-on knowledge of space regulation. And I asked her to take a look at the question of what the Outer Space Treaty does and does not cover that might be of national security interest. And I think we're in for an interesting presentation. I hand it over.
Thank you, Henry. And just to clarify, my consulting firm is not nonprofit, just to so okay, next slide, please. All right, Henry covered a little bit of the history, but I do want to remind everyone that the Outer Space Treaty was negotiated during the height of the Cold War between the Soviet Union and the United States. So there were a lot of tensions. The United States had reacted very poorly and angrily at their President Eisenhower when the Soviet Union put Sputnik up, and people were claiming he ceded the high ground and all sorts of horrible things. So it was the whole UN effort to get to some generally acceptable principles was taken very seriously and being pursued hard. The negotiating history, one of the interesting aspects of it that I find as a lawyer is that the president had asked Supreme Court Justice Goldberg to step down from the bench and become the US's ambassador to the UN, probably for a bunch of political reasons that we don't need to go into. But and then while he was there, Ambassador Goldberg became the chief negotiator for the United States on the Outer Space Treaty. So we have a Supreme Court justice negotiating this particular treaty, which is kind of cool. Next slide, please. Now, one thing about interpreting treaties, my sons are both software types, and I was like, it's not code. We don't have zeros and ones here, but we are supposed to read all the words, and we are supposed to read the plain language. And so if a court is looking at a law, whether it's in a law passed by Congress, a regulation written by the FAA, or a treaty, the plain language governs. So no one should say that the word may not means may or anything like that. You really got to read what was written down and don't go changing it around, because we assume that the drafters said what they meant and meant what they said. And all of you who work on the Hill, I know it's more complicated than that, but that is how the courts should and usually do look at it. Now, that's all very well for when something's perfectly clear. But if a treaty text is not clear, if it's ambiguous, then the courts will start looking at negotiations and what was said during the meetings that were being held, what was said on the floor of the General Assembly or on the floor of Congress. And so for that, the courts will start looking at intent and try to figure out what the people who passed the treaty or the law meant, but only if the language is not already clear. Then there's something called customary international law, and it too may apply when a treaty is silent or contains undefined terms. And it's pretty complicated, but at a very top level, you can look for custom to grow up over years, decades, centuries, by looking at state practice. What have states habitually done in certain circumstances? And this doesn't mean once or twice. This means in a settled sort of way that they always follow. There also has to be, there's another part to figuring out if something is customary international law. When a country does something that might give flesh to some ambiguous treaty term, they should be doing so out of a sense of legal obligation. The courts will want to know whether they felt legally obligated to do this or whether they were just being nice. So you have to look at both of these things to figure out if you've got customary international law. And one of the things that I think we need to be mindful of in the space law context is that even though it's been, a long time since we walked on the moon and we've got lots of things in orbit around the Earth, there's lots of things we haven't done. And for them, we don't really have a lot of custom or settled state practice yet. So keep that in mind if you're doing a legal analysis on this. Next slide, please. Okay, so one of the treaty provisions in the Outer Space Treaty is Article 4. And it says that countries will undertake not to place in orbit around the Earth any object carrying nuclear weapons or any other kinds of weapons of mass destruction, install such weapons on celestial bodies, or station such weapons in outer space in any other manner. Now, my brief from Henry was to figure out what was clear and easy to see in the outer space treaties and what was a little more ambiguous that people might argue over. And so I came back having read it and knowing that I'm supposed to read the words that are written. I said, okay, this one's clear. No weapons of mass destruction or nuclear weapons in full orbit around the Earth. Now, what is a weapon of mass destruction? That's a little less clear. And some scholars say that the ambiguity creates a lot of leeway, but we do have the treaty's negotiating history for a starting point. So remember, you get to go look at the negotiating history when things aren't clear, and this particular treaty doesn't define its terms in a nice little list of definitions up front, like we like to see. But we do have both the testimony of Ambassador Goldberg to the Senate during the ratification hearings, and as well as other members of the administration's negotiating team who said that a weapons capacity for annihilation is on par with a nuclear weapons capacity, then it's a weapon of mass destruction. So that's not getting us a lot closer, but it does suggest that, you know, a Glock is not a weapon of mass destruction, or a bow and arrow, or anything smaller than something that will be on par with a nuclear weapon. So
By the way,
we'll
that
have
is a
easy
very
cases.
important point, because if you take a look under various legal codes in the U.S., the will to say that you're dealing with a weapon of mass destruction administratively and bureaucratically has been so strong. There are legal definitions that define it down to, uh, less than a kilogram of explosive. I mean, it's so knowing what they said about this treaty is pretty important to hedge against the nonsense of dumbing it down to minuscule amounts of explosive.
Thank you, Henry. Next slide, please. So sticking with this same provision here, it is clear that other weapons in orbit are not forbidden. And we do have a little bit of state practice for that, which I learned in a meeting with NASA one day, back when I was at the FAA. They're like, yeah, the Russians always take rifles with them. I'm like, what, to repel borders? What are those for? But apparently when they come back and they land in Siberia, it is full of dangerous animals like bears and wolves. So they need to have something to defend themselves. So they do take their pistols and, according to NASA, rifles with them. Now, you know, again, remember we've got a prohibition on weapons of mass destruction. So ASAT weapons, jamming, and cyber attacks are not clearly prohibited by Article 4 of the Outer Space Treaty. And one thing that was also clear from the negotiating, from Ambassador Goldberg's testimony to the Senate, was that military reconnaissance, navigation, and communication satellites are all okay too, also not forbidden. Now, I say all this, you know, yes, you can take up your pistol and your rifle for the bears, but we should be mindful of Article 9 of the Outer Space Treaty, because it calls for states to conduct their activities in the exploration and use of outer space with due regard to the corresponding interests of other states parties to the treaty. So if you were to just like start going a spacewalk and start shooting randomly and creating debris, that might be something where other countries said, hey, that's not, you're not showing due regard because you're creating little bits of debris that are going 17,000 miles an hour and could take out, you know, my inhabited space station. So the use of those weapons is something to keep in mind against Article 9, because there are these catch-alls out there lurking for bad behavior. Next slide, please. Now, as Henry mentioned earlier, Henry Hertzfeld, this same provision makes it clear that weapons of mass destruction are not allowed in a full orbit around the Earth. So here you have Earth, here you have a full orbit. But what if you have a partial orbit? Well, ICBMs aren't forbidden, the intercontinental ballistic missiles carrying nuclear warheads, on the grounds that they aren't stationed and that they are just passing through, so they are not in an orbit. And I was surprised to see the altitudes they reach. They're clearly in outer space. They are clearly in excess of, you know, orbiting altitudes, but they are just passing through, so they're not there permanently, and they don't enter an orbital trajectory. But the interesting one, and the one where I think that there's some ambiguity, is this partial orbit. Even before the passage of the Outer Space Treaty, the Soviets had created this fractional orbital bombardment system where they could put something into a partial orbit so that it would orbit the Earth a bit, like a third of the way around, halfway around, and then it would come out of orbit and it could like zoom up, and this ICBM could then zoom up the west coast of the United States and take out some of our facilities. And this is one where you start thinking, I wonder what constitutes state practice here, because they did go and build 18 silos full of these things. So is that state practice? And I'm sort of hoping Jack will talk about this because I'm curious. And then we have, more recently, the Chinese have created these hypersonic glide vehicles, which also get into a partial orbit. And then we have the United States did not, that I found in my research, dispute the Soviet FOBs. And recently, in this century, DoD legal guidance manuals have said that fractional orbits likely do not violate Article 4. But if I were like running a war game or still in the government and had this kind of responsibility, I think, but gee, you know, some of the plain language nowadays, and you'd have to check what it was back in the day, but some of the plain language nowadays is that you've reached orbit, that you're in orbit, even before this is how my engineers talked when I was back at the FAA. You haven't achieved your full circumnavigation of the Earth, but you are still in orbit. So I wonder, would history look back on someone who thought that this didn't violate the treaty as, a wrongdoer and someone who did violate the treaty? So I consider that a sort of interesting matter of ambiguity here, and that it could be interpreted either way. Next slide, please. Okay, now here's where the lawyering gets, some people would say, over the top, because there was this really cool space lawyer who became the director of McGill, which is a very internationally well-known aviation and space law institute. He's pretty cool, actually, and I know I'm going to run up against my time, but I have to tell you this story. Nicholas Matt was a Romanian who escaped the oncoming Russians when he was in his early 20s with his new bride, defying her family, and fled the country to get away from the communists. They faked their deaths and eventually moved to Canada. And then he became a space lawyer. They lived in France for a few years under assumed names, and then they moved to Canada. But he pointed out, and I thought this was interesting, that when you don't mention the moon for this particular prohibition about weapons of mass destruction, and the rest of the treaty talks about the moon and other celestial bodies, the moon and other celestial bodies, did it mean that you could put WMD on the moon? So those are the kinds of things you try to figure out, like when you're in litigation and you have a law that you're reading and yes, it matters that the moon is omitted here. But historically and over time, I think that his concern has proven to not be a concern, because there are other strong indicators that the drafters included the moon as a celestial body, including in the title of the treaty, as Henry pointed out. In any event, there is another provision that says that stationing such weapons is prohibited. And so we should figure that would cover this particular situation. Next slide, please. Now, again, Henry touched on this. Where is outer space? Well, we know clearly from the negotiating history and Ambassador Goldberg's testimony that objects in orbit are in outer space. So is the moon. But airspace is not. So do we want to define it? Historically, the US government has been adamantly against defining where outer space starts. There was once an issue at the FAA where I thought, oh my God, we're going to get to define where outer space begins. And the State Department very diplomatically made me think that we were going to get to, but no, I was wrong. So you don't get to say where outer space starts. And it's a good thing, because let's say you have a spy balloon that you want to take over someone else's country. Well, remember, there's no sovereignty in outer space, so you get to go here and there, consistent with all sorts of other treaties, but you get to go over someone else's country and look down on it. And if you're in outer space, they can't get mad at you. But if you're in their airspace, they can. Now, if someone's over your country, you might want to say, my sovereign airspace extends very high, and it sure extends to reach your balloon. But if you've got a balloon over someone else's country, you want outer space to be lower. So until we have to resolve this, we'd rather not. And we might want to not have that sticking out there as a problem for us when we confront one of these situations in the future. So those of you very familiar with who remember the Chinese spy balloon, it was exactly that sort of situation that the United States has held off on for, if I may end my sentence with a preposition. Next slide, please. Okay, now here's the peaceful purposes question. The Soviet Union wanted to say that peaceful purposes meant nothing military could be going on. The U.S. has consistently taken the contrary position that you can have that self-defense is certainly peaceful. And, philosophically, you could argue, that strength makes for more peace than not. So taking this position is probably good policy. And legally, Article 3 of the Outer Space Treaty incorporates the UN Charter, which does allow for self-defense as a peaceful purpose. Next slide, please. Okay, again, the establishment of military bases talks only about celestial bodies, but not the moon. So that earlier concern of Dr. Mott's might apply here. But the Law of War manual puts that concern to rest. If you are a part of the U.S. government, then you would be mindful of what the Law of War manual says from the Department of Defense. Also, the treaty does make clear that military personnel are not prohibited, and any equipment or facility shall not be prohibited as long as it's for peaceful purposes. Next slide, please. Okay, now here we do have the moon being included in this little phrase, which is, part of the reason Dr. Mott had those concerns. And it requires reciprocity. If I have a moon base and you have a moon base, we should get to visit each other's moon bases. We should also give each other notice so that, everyone has enough oxygen for the visitors, and so that visitors don't, mess up someone else's property or interfere with their scientific experiments. But we're supposed to let each other in. Next slide, please. Now, this was one where I went through the process of rereading the Outer Space Treaty to write this paper for Henry, and I was like, oh, look at this. Who knew? Does the treaty apply during war? Well, General Wheeler, in his testimony to the Senate during the ratification hearings, said it would not apply during war. The more recent legal statements from this century from DOD said it would likely not apply in an exercise of, kind-hearted diplomacy. So I think it would not apply myself, but again, military experts might have more to say about this. So that's next slide, please. I don't think there is another one. I think that's my last one. And that's all. I think I made my 15 minutes.
Yes, I'm going to exercise the prerogative of the tyrant here. Two questions. One, during war, does anybody here, including the speakers, have clarity as to how you would define being in a state of war? Number one. And then number two, a more technical and self-serving question. My center ran a game where the North Koreans used a medium-range missile to insert a nuclear explosive at about, I think it was 100 miles up. We'll just say 100 kilometers up, just to make legally interesting. And it wasn't enough energy to put the object into a full orbit, but it was enough to get it into low Earth orbit, and it exploded. Curious to get your thinking on the legality of that under the treaty. Keep in mind that they are not signatories to the Threshold Test Ban Treaty and not subject to that restraint of testing in the atmosphere or in space under that treaty.
Allow me to
Well,
talk.
no. Hold off. I'd first like to hear from Ms. Montgomery, because we've had some conversations about it. Then we'll turn to you, Jack.
Well, first of all, low Earth orbit is still orbit, but 100 kilometers would perhaps trigger the country who had this EMP detonated over it to say our airspace goes that high. I don't think there would
And
be
at
universal
100
agreement
miles?
with it.
At 100 miles?
You'd be surprised. 100 kilometers, 60 miles. So,
I say
I
if you
don't,
went to 100 miles,
oh, if you, okay, so
do you get,
that
does that
would be
eliminate
much
that?
harder. That would be much harder,
Okay.
but it would certainly make someone think, should we make a sovereign claim here? I don't know that they would, because there's lots of other reasons not to. So this is pretty tricky, and it seems to me it might be, as long as it's not actually in orbit, it might be on the order of something similar to an ICBM. But I really would like to hear what Jack has to say
Yeah,
on
no.
this.
I wanted to make sure there was creative tension based on first your presentation, then commentary. And a state of war?
That's a silly term. It has no international legal meaning whatsoever. It's up there with war on poverty and war on drugs and war on obesity. Really, abandon it, leave it. Don't worry about it, Henry. Keep it out of your life. Your question
Okay.
is whether or
All
not
right. Whoa. Slow down just a little.
What is the term? Say it again.
You're saying something which, if improperly interpreted, would suggest that the treaty, when it refers to war, is surplusage. So,
the treaty doesn't refer to war.
It says, as long as it refers to peacetime.
Yeah, well, it doesn't look. There's
Well,
no.
no, but what I'm
moment
trying to
in
get
the
at, look, should not be personalized. I'm trying to raise to the attention of the students what the character of these terms might be and how they might be interpreted. Not, it's just not anything more than that. Okay.
I'm a
So
lawyer.
the question
I'm a
is,
lawyer, and
is there a difference between war and peacetime that has any legal validity or not? Now, if it doesn't, that's really interesting.
you're starting from the wrong place because the term you're using isn't a useful term. That's the point I'm trying to make. The question is the UN Charter and whether there's a use of force and whether there's an armed attack. There's no such thing under the UN Charter as war that was abandoned because it didn't work in the League of Nations covenant. It's the wrong
I
term.
see. Okay, Laura, I thought that I misunderstood saying that something about the word peace being used. And you were making an argument about when it applied and didn't. And you said, well, it wouldn't apply in wartime.
That was the language used by General Wheeler, the
I
chairman of
see.
the Joint Chiefs of Staff. It is not in the statute, in the treaty, the war, but when you look at the treaty and it's like, this is the treaty that governs the peaceful exploration and use of space. So all of these rules apply while you're doing peaceful stuff. And so this is the logic, as far as I can see, of why General Wheeler would have made that statement. And that's why I was curious. Jack has some.
Of course,
Okay, now
you hit it on
over
the
to you,
head
Jack.
before, Laura. You had it.
I'm
you hit
sorry?
it perfectly. You hit it perfectly before. Self-defense is an entirely appropriate activity, and blowing things up and killing people in self-defense is something that we don't call technically war. It's the exercise of self-defense in response to an armed attack, right? So you answered that question when you were talking about the application of the UN Charter. And what an American general says, talking about it, American politicians use and abuse the word war all the time.
That's
but
just
it has
looser
no international
language.
meaning.
Right.
You were right on before.
Okay.
And do you have a comment before we should probably spend another 5 minutes with Q&A on Henry's presentation and Laura's, but Jack, do you have any views with regard to the insertion in low Earth orbit with something as a rocket that couldn't put it into full orbit, whether that would be quote unquote covered or not with regard to the question of orbit?
I'm the lawyer. When you say covered, what do you mean?
Well, it says you shouldn't put a weapon of mass destruction into orbit. If you
That's-
use a device that can't put it into orbit, that gets it into low Earth orbit in altitude, is that inserting it into orbit or is it not covered?
Just because you get it up to that height doesn't mean it's in orbit. But
Got it.
okay, that's the first problem. The other problem is that the Soviets and the Americans both had intercontinental ballistic missiles when this thing was being negotiated. There was no way they were going to write anything into the treaty that prohibited things going up and touching and coming back down, because that was the definition of the devices they had in their arsenals at that moment. So, you know, it goes up, it touches, it comes down. You're gonna probably not be able to argue that's an Oregon. And as Laura said, DOD has taken a very clear step about not considering fractional orbits, FOBs, as being prohibited by the Outer Space Treaty because they're not in space. And that's interesting DOD interpretation. I know you've been concerned about that before, but that's where we stand.
Let me add one little quirk on here too, and sometimes it will depend on what country you're over, because there are some equatorial countries that claim that they own everything. Colombia is one of them, I know,
That's
as well.
that's not quite what they said. That he's right. The Bogota Convention has the equatorial states all unhappy, sitting there looking at AT&T and Verizon making a fortune in the area that's above their country. But they kind of finessed the way they said it. They said that it's not that we're claiming or appropriating it. It's that gravitational field that goes up there is their natural resource, a use cogent's natural resource. And so they've made a clever argument, and they haven't signed they've signed the Outer Space Treaty, but several of them have not signed it. They haven't actually attacked the Outer Space Treaty. They're suggesting that there's a rule of customary international law about their natural resources that extend up to space.
Yeah, early on, there was somebody in Colombia that wanted to launch a CubeSat, a small satellite, on a Russian vehicle, and even the Russians wouldn't do it because they hadn't signed or ratified the Outer Space Treaty. And I think they eventually made a statement about the fact that it was for peaceful purposes. Eventually, Colombia signed and ratified the Liability Convention, and the Russians launched it, but they still haven't ratified the Outer Space Treaty.
But the Outer Space Treaty is growing, and we just got a new member near the equator with Oman. I always root for the countries near the equator that join.
Sure.
Let's open it up just for a few moments, and then we will get to our last presentation, and then we'll open it up again, both for Jack for a certain dedicated period, and then to everyone for anything afterwards. Questions, hands, comments?
There's a bunch of questions in the chat.
Oh, well, why don't you moderate that, Brooke? Why don't you take over?
There's a question by Albert Gardner, who also just raised his hand.
Speak up. Don't be shy. Well, we're going to have to read it, and if you won't speak up, why don't you read the question?
I think he's on mute.
Well, other than that, he's doing fine then.
Asked, is there an advantage to declaring the von Karman line as the beginning of space?
That's a good question.
Not for the United States.
Well, as I said earlier, there's lots of good reasons not to prematurely declare anything the beginning of outer space. As a former FAA person, you know, if it was just up to the FAA, you would do it all on the basis of whether you're operating under principles of lift or thrust. So, you know,
can you explain that just a little so everyone knows what you meant?
So airplanes, you know, when you stick your hand out the car window and your hand goes up, you know, when the car's moving, That is, sorry. That was me, sorry. That's lift, and that's how airplanes operate. When a rocket goes off, it's, expelling fuels out the bottom and it's, getting pushed up into space. So, um, there's a strong contingent at the FAA that would do it based on technology rather than, um, and then of course would have to start looking at how much atmosphere you have left for whether you have thrust or not, and then people would start arguing about ramjets. But politically, I think I kind of agree with the U.S. position, even though they took away my moment of glory, in that we shouldn't say where it is until, I mean, with the Chinese spy balloon, we can say, hey, you are in our airspace, get out. We are unhappy, or have taken more stringent measures if we had chosen to do so. No comment there. So I think that waiting until there's an actual case or controversy in front of you is all to the good.
Let me add that the liability convention, when they define Article 1, also includes in the liability the intent to go to space. In other words, if you launch and there's an accident in airspace, it still could possibly be interpreted as an international incident under the liability convention. I think for all intents and purposes, if it happens in national airspace, it wouldn't be, it would be under national law, but there's a possibility of an legal interpretation that would put it under international law.
Right. If you launch from your border and hit someone in your neighboring country,
Yeah.
you could have that get looked at.
Or over the high seas.
Yeah.
Mhm.
Brooke,
There's a question from Gabriel Mons.
Mr. Mons,
Can you hear
speak
me?
up. We can. Shoot.
Finally works. Yeah, if we had a major accident, like Henry was saying, we have a lot of capital out there. Isn't the International Court of Justice and the UN Charter, Article 8 and Article 3, wouldn't those be the first tools that we would use? Just trying to figure out if we had a major accident, what would be our approach?
What kind of accident are you talking about?
Okay, well, let's say the space station. We lose the space station with
How?
astronauts.
How?
I don't know.
Hit by debris, hit by an enemy adversary, what?
That's a more likely situation. Let's say we have debris that puts it out of orbit. Wouldn't we use the international law tools that we have to settle that?
Well, the International Court of Justice is only going to be hearing cases between states with a legal dispute that both parties agree the court is going to hear. And so it doesn't get a lot of business when the superpowers are involved. So the ICJ is probably not your place. As noted by Henry, our first speaker, you're for dispute resolution. You're pretty much stuck with negotiation right now, except the liability convention, as Henry knows and talks about, has a provision where you can agree to set up a panel to do it. But no, that's not the superpowers have avoided being bound by many international court proceedings. Russia just got tricked into being pulled in to the ICJ for calling the Ukrainians committing genocide. They find themselves in the ICJ for about the first time ever. But no, unfortunately, there is no world court system that works the way a domestic court does.
Why don't we take two questions at a time, given the number that we have, so everyone can have a chance to have their question answered. I see Mr. Singleton and I see Mr. Gardner. Why don't we take those two questions? Speak up, and then our speakers can deal. I think they can deal with two questions at one time.
Yeah, this is Daniel Singleton. Good afternoon, everybody. My question was with respect to those 5 treaties. Are there ones in particular that you would say are more or less important, or do they all reach sort of the same level of importance?
No, I would strongly argue there's only 4 because the Moon Treaty is a failed treaty. It doesn't have any major spacefaring states. And actually, the Moon Treaty is the only one that is shrinking right now. Saudi Arabia just announced they're pulling out as of January 1st, 2024, because they've joined the Artemis Accords. And the Artemis Accords involves not sharing resources, but exploiting them for the benefit of whoever's up there. So being in the Artemis Accords and being in the Moon Treaty, there's quite a bit of tension there. So Saudi Arabia signed the Artemis Accords and is pulling out of the Moon Treaty. The Moon Treaty also, the shared resources provisions are not popular with a lot of countries if they're going to go up and do, much like the Law of the Sea Treaty wasn't popular when it had similar provisions. And the Moon Treaty also has a prohibition of hostile activities and the threat of hostile activities, which is the only treaty out there that says something like that. Who knows what a hostile activity is? So
Yeah, I would agree with Jack on the specifics of certain parts of the Moon Agreement, but I think there's some other parts of the Moon Agreement that shed a little bit more light on the other 4 treaties. For example, in the Rescue and Return Agreement, it talks about the rescue and return of astronauts and defines it, and then participants in space. Whereas the Article 10 of the Moon Agreement is really is quite a bit more general in terms of, hey, if people are endangered, we're going to try, if you can, nations should try to rescue them. So I think you can look at certain things in the Moon Agreement, other than things Jack was talking about, and say there's some positive things there. It brings in the word exploitation of space. It says use and exploitation. So in some ways, it's more commercially specific than the other treaties. And Article 6 also allows for research purposes, nations to dig and to mine in the moon and to find out what's there. But more specific to the question that was asked, I would say focus on the Outer Space Treaty. It is the master document. The other treaties add to and build on some of the paragraphs in the Outer Space Treaty.
Okay, thank you both.
And also remember, the only countries that are bound by the Moon Treaty are the countries that are parties to it. So Mexico and the Philippines care. But the Outer Space Treaty, as Henry said, not only is it the guidebook, the master, the one that's got the most countries and all the major space players, but big parts of it are also probably customary international law at this point. At least a number of countries have come forward and said so. And it's also really important, again, on Henry's point, it is the rule book. It's everyone up there. Just about every single thing up there is associated with a country that's a party to the Outer Space Treaty.
Well, and even Iran and North Korea ratified that treaty before they launched anything years ago now. Now, whether they abide by it or not and how they abide by it's a different question, but they did ratify it.
That's a fun topic. That's coming up.
Okay. Having failed to get 2 questions first before replies, I'm going to try again. Let's hear the question from Mr. Gardner and then Mr. Moon first before we try to answer the questions. Can we get those 2 up on the net to give us their questions?
Hello, so can you hear me now?
Yes.
Okay, I'm Elfrid Gardner here. I suspect I know the answer to this question based on the answer that I got from the previous question by Ms. Montgomery. But the question is regarding weapons of mass destruction and ASATs. There are some who might argue that given the widespread destructive nature of an ASAT, it might be considered a weapon of mass destruction insofar as the space domain is concerned. And I wonder, do you see merits in that argument worthy of amending the typical connotation of what a weapon of mass destruction is?
Okay, don't answer. Let's get the second question. Mr. Moon.
Yes, good afternoon, and thank you for your presentations. Some of my questions, well, at least some of its parts have been answered already, so I appreciate that based on what others have asked. However, usually past dependents always carry over with future negotiations and future domains and or multilateral treaty. I would say political scientists always argued that. What lessons can be drawn in regards to nuclear deterrence or nuclear negotiations in the past and the current but yet not resolved cyber and obviously the upcoming AI regulatory frameworks at the international stage that we can actually draw upon on space domain? Thank you.
Okay, our speaker should have at it.
I have one
Well-
quick comment, just one quick one. Of the things that you mentioned, the only thing out there, ironically, that has a treaty that all the major players are a party to is the Outer Space Treaty. Cyber has nothing like that. Nuclear has its different components that you've already studied. We can talk about, but space is a unique place with a treaty made many years ago for the future. It's where peace and predictability and sustainability is going to have to come from, if anywhere.
I'd like to take Colonel Gardner's question. And
Yeah.
so as a lawyer and a language purist, I would argue against expanding the definition of weapons of mass destruction, mostly because there's all sorts of agreements and language out there where people voted on them or signed them with one understanding of what they were agreeing to. So if you want to say ASATs are bad and we need to prohibit them, do so, but have an agreement that says ASATs are bad because they cause debris. Because the ASATs are not taking out cities like we saw, in World War II. So, so they are not, as the negotiator testified, on par in terms of the equivalence of their destructive capability. So I would say don't do that as a matter of legal hygiene. Say you don't like this thing that you don't like. Don't try and shoehorn it into a category where it doesn't go. That would be my thought on that one.
Yes, agreed. And if there is a norm, it's that you can continue doing these destructive anti-satellite weapons tests, because that is unfortunately they have reoccurred now. But more on that when we can talk about that later.
Okay, why don't we take the next two questions? It looks like Mr. Wood and Mr. Ogden should speak up and articulate their questions.
Sure. So my question was a pretty quick one. The response might not be as quick, but I was mentioned by the previous speaker that the moon is likely argued to be a celestial body. What would be the argument against the moon qualifying as a celestial body?
Okay,
Well,
hang
the
on, please. Let's get two questions. Sorry, we'll never get through here. Okay, and Mr. Ogden.
Yeah, thanks. I just had a question about the Woomera manual and the McGill manual that are both being worked. If any of you are working on those projects, if these are meant to be a basis for some type of international legal global military to govern military space activities, what do you think of these two ongoing projects? Thanks.
Okay, now that we have the two questions, fire away at will, all three of you.
May I do a really quick one on the moon
Sure.
as celestial body?
Yes.
That was, I wasn't saying, Dr. Mott was not saying that it isn't a celestial body. He was saying that the restriction in the treaty wouldn't apply to the moon because it was being omitted from that sentence. So there really isn't an argument about whether it is or isn't one. It's just whether you can have weapons of mass destruction on a celestial body. And oh no, they didn't say the word moon here like they say it everywhere else in the treaty whenever they mention celestial bodies. Does that mean you can have weapons of mass destruction on the moon? Because you know, so that was the origin of that concern.
Yeah, I
Does that
think
help?
the moon is a celestial body in the law. I think we agree on that, at least in the space law. The only thing that answer your question, how might it not be, is that it's the closest to the Earth. And as you know, there are some people on Earth that some religious practices, the American Indians, some others, it has some emotional content to it that an asteroid doesn't have, for example. That's not an argument to treat it differently legally. It's just a recognition that there may be some pushback on the Earth when we talk about the moon that will be different than when we're talking about some other celestial bodies. So I'll just leave it there. I don't think that's a discussion we want to get into here, but some people will regard it differently.
Comments on the second question?
I will take up some of that when I talk, since I'm the editor-in-chief of the Woomer Manual.
Okay. Shoot.
I mean, I that's one of the things I was going to talk about. So,
Okay, all right. Well, so we'll hold off then. The last, let's see, how many more questions do we have here? On here. Brooke, why don't you take over? I would have the last of all of the last 4 questions be asked, and then let's call it quits here. Why don't you take over, Brooke?
Are you asking me to read them out loud, or what are you asking?
Yes, if you would.
So Casey Galenik asked if a state or group of states practice norms continuously that are in language of a treaty legalistically defensible but run counter to treaty debates, at what point is the norm more legally relevant than the debate and intent? And Carl Sandifer asked, I focus heavily on utilizing nuclear power systems, plutonium-238 based, to enable missions in support of space science exploration missions, typically at Mars and beyond. Do you see any implications or WMD perspectives of enabling similar missions near Earth or around the moon? PU-238 is perceived as non-weapons grade. From Savannah, with the surge in space commercialization by private companies, do you think it's time to update space liability laws? If so, what are the most glaring issues to be addressed? While it's international space law to give other countries notice of tests you're conducting in space, it's customary / unspoken space law that countries don't really do that when it's military focus or national security related, i.e. often countries don't share notice of weapons testing. Do you think long-term this will have more negative than positive implications? Is the status quo fine, or is this something we should take action on to explicitly dictate and enforce procedures for? And then the last question from Kunal Joshi was, what about Australia and France? They are signatory of Moon Treaty and Artemis Accords.
Okay, that's an awful lot to give you a shoot at, but let's do that and call a break here, so that our 3 speakers can tackle the questions they've heard as they are most attracted to one or the other to answer.
I'll quickly answer the last one. France is a signatory to the Moon Treaty, but will never ratify it. They have no intention of ratifying it. And you're not bound by the terms of a treaty if you're a signatory and you haven't gone through the continuing procedures to become bound. And once you announce you're not going to do it, then you have no obligations at all. You are correct, though. Australia is in a conundrum. Australia can't resist signing treaties. And they're having a debate internally about what they're going to do. They wanted to join the Artemis Accords. They regret joining the Moon Treaty, and they'll end up having problems with their military forces with having different obligations at some point on the moon than others. But that's the answer to that question.
Yeah, I'll just talk for a second or two about the liability. Yes, I think there are changes that will have to be made eventually. As I mentioned, states are ultimately liable and in unlimited time. It's interesting that space is the only industrial activity where states are ultimately legally liable for international liability, meaning and it's aimed at innocent victims, third-party liability. But we really will, with more commercial companies up there, private companies, both the United States and elsewhere, we're going to have to look at that carefully. It's going to be a very difficult thing to change by treaty. But it might be possible for nations independent of the treaty to have different multilateral and bilateral agreements on liability as well, so that it's not going to happen fast. But I think it's something that's going to have to be looked at carefully in the future.
And if I could just close out on the liability as well, Savannah, you might be interested to know that the United States actually has a pretty solid liability regime in place for damage caused by rockets, by launch and reentry vehicles. So there's a law passed by Congress, and it tells people who are launching rockets to go buy X amount of insurance. And that is still in place. It's going to be in place for a long time. So what the United States has done is turned around and passed its liability onto the people who might actually cause damage in the commercial context. So I think that's great, and it takes care of some of those issues of unlimited international liability. The glaring issues, well, one of the issues that's being addressed as well that's really fascinating is that space tourists currently have to sign waivers of claims with the launch operator. The thinking was, if you're going on a rocket, that's like, climbing Mount Everest or some other hazardous activity. And so you shouldn't make a claim if you get hurt or killed, and neither should your estate. So those cross waivers are American law, and they are in place right now.
And they're remarkable. They are truly remarkable. The government says it's not safe. You are taking everything on board, and SpaceX makes a would-be space traveler sit through an hour-long presentation showing all the disasters that SpaceX has had, all the explosions, all the stuff.
That's a good way to
and make them watch. The lawyers for these companies have done everything they can to look. They knew what they were getting into here. This is dangerous stuff. It's really it's a humorous story. If we had more time to talk about it,
and also
the law and the regulation require that, because there has to be informed consent.
Well, within the United States, actually, those informed consent paragraphs that are determined at the state level, not the U.S. government level.
No. Those are federal. Those are federal regulations, and we took them on as a federal thing. It's in the law.
Not the wording. The wording is enumerated in the New Mexico, the Texas, the Florida laws.
Also in the appendices to 14 CFR Chapter 3. So there are waivers that the FAA requires you to use currently word for word. Not to the tourism level yet, but that's just because they're starting that rulemaking.
And besides, the FAA can require anything they want. There won't be a launch license without agreeing to that. So the feds have a big upper hand. Not to say the states aren't playing games in it too.
Yeah.
I mean, Henry is perfectly right. The states all have laws. They're very in sync with the federal law, though. So that's a good thing.
Okay. Did anyone want to tackle any of the other questions? I think there were two others.
Oh, the first one I could just quickly say, a few countries that are not going with other countries with respect to some practice they're engaged in is not enough to make a new rule of customary international law. If, when a new rule is being formed, you're a country that systematically refuses to ever join, you might get to be a so-called persistent dissenter, so that someday, if it does become customary international law, you are exempt. That is very rare, and that's when the rule is being formed. So it's a high standard to get to customary international law, and it's an extremely high standard to then, once it's there, try to change it. And everyone talking about new space regimes, the Outer Space Treaty is almost incapable of being amended. It's got a really strange amendment clause. You've got what you've got, and it's going to only be modified by state practice, which is permissible under the Vienna Convention law of treaties. If states agree to interpret these terms through their practice or agreements, some of the ambiguous terms can find meaning. As Laura was discussing there earlier.
All right. Well, two things now before we proceed. I am applauding the 50% that have turned on their camera, and I am urging the second 50% of the class to show the courtesy of doing the same. And you know who you are. Some of you may not technically be able to do it, but I kind of suspect it isn't all 50% of you. Please, if you would, turn your camera on. I appreciate it. Okay, now if you wondered why there are three, it's because these are the three people I know that I think are interesting. Okay, that's one way of coming at it, but it turns out that there's another reason why we have three. NASA Civil Space, Mr. Hertzfeld. Ms. Montgomery, arguably most engaged on the commercial side at FAA. And then last, but certainly not least, Jack Beard. Well, he served in the Pentagon for 14 years as a lawyer on a number of things, including definitely this topic, and now teaches at and is director of the Cyber and Space Law Program at the University of Nebraska College of Law. So so we're covering all bases here, and I wanted to make sure that we ended on the D for defense, if you will.
Okay.
Okay.
Yes, I served 5 secretaries of defense in the Office of Secretary of Defense and the General Counsel's office, and my responsibilities revolved most around international agreements that the Defense Department was entering into. Some details to the State Department and a lot of experience with my friends, the Russians. The other aspect of my career is probably, I was a student at Leningrad State University. I speak and read Russian. I was the negotiator for a lot of agreements that we reached after the Soviet Union collapsed. And during the time, there were various demilitarization and non-proliferation initiatives. And so I've spent a lot of time with the Russians, and that informs my talk here today too for you all. So if I could now call this up for you. Here we go. I am the director of the Space Cyber Telecom Program. I view it, I just skipped over there. I view it as a very serious job. We have, I have military officers from all of the branches, and now I've got Coast Guard coming up here this year as they get their degree and go back to Cybercom or Space Command or Space Force. It's a pleasure teaching people that in this area who are then going literally as lawyers back to the front line. I have been burdened for the last 5 years of my life as the editor-in-chief of this document which hopefully will come out, if not at the end of this year, the very beginning of the next one. It's it goes slow because it's Oxford University. And it is the definitive statement on state practice with respect to each and every bit and part of the Outer Space Treaty. The picture at the left is a meeting sponsored by the Dutch Ministry of Foreign Affairs last summer, where they invited the foreign ministries to send their lawyers and the defense ministries too, to review a draft manuscript of the manual, which they did. We spent 3 days with them battling each other, and it was terribly entertaining and interesting. And it's really important for me because the WUMR manual is founded on the principle that it's states that make international law. They are the creators. That's the way the system is set up. It records and discusses and examines state practice with respect to the Outer Space Treaty in peacetime, in times of tension and crisis, and what happens when there is an armed conflict. There's another manual out there by McGill. It doesn't cover the full spectrum. It doesn't discuss the law of armed conflict, and it relies more on academic content. We've tried to avoid the academic content in WUMRA and get as much as we can from states, which is why this state engagement process we went through was so valuable and so important. So look for it in bookstores soon. The 2,200 words of the Outer Space Treaty have been my life for the last 5 years. You can have a class on each paragraph if you want, but we don't have time for that. So let's not at all. That is not the way Henry's going to run this shop. Let's just make it clear. Let's make it clear what a ridiculous situation we have. The military basics are these incredibly valuable things, these satellites on which our Defense Department is so dependent for the bombs where they land, for the ships where they go, for the drones that are operated. They were put up there in an era when they were judged to be safe. But if you think about it, they're hopelessly weak and vulnerable. They're fragile. It costs a lot of money to launch things into space. You can't put armor on them. Something hitting armor at 22,000 miles an hour doesn't do very much for it. They're traveling at incredible speeds in near Earth orbit, and that puts them in danger all the time, along with all the increasing debris. There is the other reality that you know exactly where they're going to be. If you're going to shoot at them, they're not hiding. There is an orbit that is cataloged, and all of our adversaries keep track of it, and everyone knows exactly where they are. And although the U.S. government spent billions on this a couple of years ago, you can't camouflage them. You can't paint them black, or put the uniforms on like Space Force on Netflix. There's no good camouflage for space. They're difficult, essentially impossible to hide. And you can put passive defenses in. You can have them with the power to maneuver, but the fuel costs money to go up, and it also runs out. And so every satellite's not capable of maneuver. In fact, most aren't. You can set up little Guardian satellites around, which our Defense Department is experimenting with. And there are different things, but it's difficult to protect the satellite from ever more interested aggressors. And down on Earth, you've got all of these things that cyber and electronic can mess with, because you've got uplinks and downlinks, and you've got controls going back and forth between the tracking sites and relay stations. And the Iranians have got pretty clever also, even though the signals for controlling the satellites is encrypted. The code is encrypted, but there's a phrase called meaconing, a new phrase entering the parlance in this area, which is to intercept encrypted information that the Americans are sending their satellites, keep it, and then beam it later to the satellite to confuse it, because it's getting a message that is telling it to do something that the U.S. doesn't want it to have. There's so many ways to mess with the satellites. Bandwidth for encrypted transmissions is small. This is a big set of vulnerabilities, and the threats are growing for the high-power microwaves and chemical sprayers and radio frequency jammers and kinetic kill vehicles of all sorts of varieties. lasers, other aspects of the electromagnetic spectrum, and of course, robotic mechanisms. So the threats are growing, they're vulnerable, they're essential to our national defense. So what are you going to do? Well, law is going to be law and the treaties are going to continue to be one of the only ways that we can get to a point where perhaps some amount of safety can be improved. But unfortunately, the other side of law is lawfare. And for your benefit here, since most of you are not lawyers, I thought I would spice it up a bit with you with some diplomacy and international affairs here, because the law is, of course, to Americans something that we try to respect. Law is a tool in the hands of authoritarian governments, whether it's domestically because you've evaded taxes for Mr. Putin and he doesn't like your opinion, or on the international stage. Interestingly, a good example, they are always trying, they are always trying to find our adversaries. They're always trying. I'm trying to go back here on the controls. There we go. They're always trying to find ways in which the United States fails and demonstrate our lawlessness. This most recently by the Chinese accusing Starlink, accusing the United States because we're responsible under Article 6 for these Starlink satellites of coming dangerously close to the Chinese space station. Invoking Article 5, which means we have to send a report to the Secretary General. Why did they choose that one? Because they can't choose the other ones because they violate them so often, is the interesting story. I mean, they didn't say, Laura highlighted a lot of these things really well. The point here is that there is a thing called due regard, but none of the sides have invoked this in space yet, although the United States just took a step with respect to due regard when it comes to debris and anti-satellite weapons tests, when I'll get to that. But you don't see China, the United States, or the Russians invoking harmful interference or due regard. The terms are there in the treaty, but the states remain silent based on political judgments, which may change depending on how much more dangerous space gets. I would also note here that the Russians in particular are absolutely fabulous at creating cover stories and legal decoys to impede meaningful legal cooperation. The poster child for that is the PPWT, a treaty that the Russians have proposed with the Chinese that is supposed to make space a peaceful place. Who can't love that, right? Who can't love it? They introduce it at the UN, at the disarmament, the first committee, the disarmament conference of that in 2011. It's got a long title, which the acronym's not really very good for it, but it's about the prevention and placement of weapons in outer space. And they speak peace, and they want to demilitarize, and they don't want weapons there because they'll trigger unpredictable consequences for the international community, which is humorous given that they just recently conducted what was clearly the first offensive weapons test in space. But putting that aside, the Russians have taken this position, and it's fabulously useful for them because, first, no one can join this agreement. It's not possible. The United States will certainly never go there. You want verification procedures? That's what Mr. Putin's going to give you under this. There are no verification procedures. There's no way to check what's going up on the ground because they certainly won't let you on the base. And when it's in the air, it's too hard to inspect. And so this document it contains all these bans on every conceivable construction of a weapon with no clear definition and no inspection regime, which would help Chinese and Russians because there's no Congress, there's no private NGOs, there's no legislature to inquire into what they're doing. But the United States would be stuck with an agreement that doesn't work. And for those of you that do arms control and do nuclear, you must always remember that verification and monitoring is important, but they are worthless if you can't define cheating. Worthless. And you can't define cheating under this agreement because you can't define what a weapon is in space. We watch TV and you always know what the bad guys are, and you know what their weapons are, and everything is very clear. You don't know what a weapon is because, among other things, anything that can maneuver in space is capable of being a weapon. Almost as Henry, the first the first speaker, Henry, said, everything in space has a military dimension. Almost everything's dual use. And for many years, the Russians accused the United States of launching this terrible space weapon, the space shuttle, because it was in their category of space maneuverable vehicles. They have a point. It's possible. The Chinese are busy launching their robotic arm satellites. They don't work the way you see on Netflix with Space Force, with the big claws coming out and grabbing the satellite and dragging it along. But again, the Chinese say, what's the problem? We're going to use this to be fixing our own satellites. We might even lob a piece of space debris out into space. It's a useful, healthy, happy thing that they're doing. So defining them is very tough. But interestingly, the United States has now taken a little bit of the high road. I wouldn't call it lawfare, but it can work that way. And that it's forced the Soviets, the Russians now, into a tough position. That's an artist's rendition of space debris. It's not that bad, or we'd all be in deep trouble. But the United States, several years ago, announced we were going to abide by tenets of responsible behavior. And one of them was we were going to seek to stop the generation of long-lasting debris. And then last year announced a moratorium on anti-satellite weapons tests. Several states joined us. We took that to the United Nations, introduced it in a resolution to embarrass the Russians, and it passed overwhelmingly by a vote of 154 to 8 in favor, with China and Russia and their sock puppets like the Central African Empire and Warner, the Wagner group. This vote was an interesting vote. It doesn't contain anything legally binding. It's just a UN General Assembly resolution, which is a recommendation. But the interesting thing about this was that the United States ensured in the resolution that this was the way states could exercise due regard under the Outer Space Treaty. An interesting development. A lot of those countries that joined in are parties to the Outer Space Treaty. Interesting development by the United States to move forward on eliminating destructive anti-satellite weapons testing, which we don't need to do, and other countries don't need to be encouraged to do it. So what's the Russian response to this? Their favorite lawfare tool, the PPWT. Hey, they say, we can't diddle around with these little, stopping debris and stuff. We want to demilitarize all of space. We want to disarm all of space. You need to vote instead for the PPWT and not waste your time on this. In this most recent meeting a few months ago, the Chinese representative was banging on our WUMRA manual, the draft that we sent out. He was saying how confusing all these rules are. Is that yes, the space is complicated, but the other thing that he said, and this is really quite intriguing, and it continues to be the Russian and Chinese line, we're not going to discuss the law of armed conflict in space. Never going to do it. Protecting civilians, all that stuff. Nope, none of that. We're not going to do it because to do so would legitimize armed conflict in space. The Red Cross vociferously disagrees with that. But again, both the Chinese and Russian representatives say, well, instead of messing with these things, instead of messing with the law of armed conflict, let's focus on dismantling weapons. Let's focus on getting rid of weapons in space. And so again, that is always held up as a roadblock to talking about just about anything. But in the limited time I have, I cannot pass without saying the Russians are truly skillful at building loopholes and traps in international agreements. I've watched them do it, and I've watched American incompetent negotiators sit back and let it happen. They violate treaties, but they abide by a number of them that are convenient when it's time to abide by them. And they also very much take the international law as an art form quite seriously. and work at finding ways to sign agreements that don't commit them to do the things the other side wants them to do. So you have to hand it to them, actually. They're excellent lawyers. And as a couple of examples, you of course, you see the blunt force at the UN, the veto. The Russians weren't going to join the UN Charter without that veto, and they're exercising it liberally. But it's more interesting to see all the ways they subvert the West and help their allies, as in the case of Iranian ballistic missiles. The Iranian ballistic missiles weren't supposed to be in the joint plan of action for the nuclear stockpiles that the Iranians were building. Recall that for many years, the UN Security Council categorically prohibited them from building, launching, testing ballistic missiles. And that was the rule until it was abandoned by a slightly less than brilliant Secretary of State who let slip into one of the annexes this clause that no longer are they bound by that treaty, but instead Iran is called upon not to undertake any ballistic missile activities, design, and so forth. This goes back to Laura's excellent point about being a very careful lawyer with the words. You can't be too careful with the words as a lawyer. The Russian representative schooled the Americans at the UN when the Americans complain about all of these increasing Iranian ballistic missile tests. He accurately says, hey, look, the resolution calls upon Iran to refrain from various ballistic, and he notes, hey, a call is different than a ban. You can violate a call. You can't violate a call. You can comply with it, or you can ignore it, but you can't fail to follow it or you violate it. And this is so true. He says the legal distinctions there. What does the American representative say to this? This is embarrassing. Ambassador Packer, Russia seems to be lawyering its way to look for reasons not to act. Well, alternatively, the United States should be lawyering its way to be more careful in the agreements that it signs. I probably will end up closing on this instead of going on to talk about Article 4 and the way the Russians have built Article 4 and Article 12 to their liking. But I would just note this goes to the point about the where you delimit space. I teach classes on what I call Soviet-Russian offensive and defensive treaty practices. One of my favorites is in the ABM treaty, where the rules were clear. You know, you couldn't use ABM systems except in a very defined area in each country. But the Russians persuaded the Americans to sign Agreed Statement D. Agreed Statement D suggested that everything would be covered if it performed ABM functions, regardless of what it was called, and regardless of the physical principles that were used. Of course, the Americans were thinking about missiles, but you can't predict that the Russians were thinking about satellites. But this was a real shortcoming in this document because it encompasses President Reagan's Strategic Defense Initiative. Both the State Department and the Defense Department agreed the treaty left a lot of problems for the United States to actually deploy a system like this. And it goes to a point that also I agree completely with Laura's points about forsaking opportunities in the future by deciding you're going to draw an arbitrary line in space. Because the reality is this agreement, more than any, teaches about the dangers of regulating unknown weapons technologies. Americans love their technology, see solutions and technological options all the time. Signing international agreements that would set a specific line up there that, if for whatever arbitrary reason is decided, and suddenly make everything that is below that line is going to be within the national control of the sovereign state below. So anyway, that's why arms control at the end, the U.S. government's not going to be eager to go down the road of ever defining this. And I'd also say the whole balloon thing is a joke. It's a joke.
Okay, time out.
I'm not. The balloon.
Yeah,
I'm out
okay.
of here. I'm out of here.
Okay. The reason I say that is you've managed to filibuster to the point where you have 3 minutes of questions. We'll have to hold you over if people want to ask questions. So let's at least give them 3 minutes worth of opportunity. Let's see here. Brooke, what do we have in the chat room?
It
All
looks
right,
like
let me.
there's two questions. There's
Yeah, well, Miss Albon, I'm going to just murder the name. Albon, I believe. Why don't you give your question? And I guess the other question, I think, is that it, or did I miss someone?
I believe there's another question from Albert Gardner, unless that was from before.
Mr. Gardner, why don't you ask your question first, and Ms. Albon, if you could do follow, and then we'll have them answer.
I just wanted to say I have to jump off for.
Okay. Go ahead. I'm sorry.
Sorry, I have to jump over the video just so you know.
Okay, well that's all right. Go ahead, ask your question.
Oh, sorry to interrupt. I just wanted to ask the
breaking up a bit.
Reserve. Can you hear me?
Is it the same question as what you put in the comment?
Yes.
Why don't I read it, because you are breaking up? Possibly related to, actually, Mr. Gardner, why don't you go first, because hers is related possibly to your question. I'm sorry, I'm really gumming this up.
Yes, sir. And they are both related. The question gets into as we continue to use commercial capabilities more under the umbrella of DoD, particularly and potentially in times of conflict, there's a lot of legal questions that come up. And so my question is, what legal recourse does a commercial venture have if it is attacked? You know, and an example that I use is Starlink being attacked by Russia and them trying to jam and destroy Starlink's ability to do what it's trying to do.
Okay. Okay. Let me read Courtney Albon's question, possibly related to Colonel Gardner's question. DoD is considering a commercial augmentation space reserve that would allow it to leverage commercial space capabilities during conflicts. What are some of the legal issues that should be considered as they develop this reserve? Okay, open season for our three presenters.
Well, on the very last one, the Defense Department is in a difficult place. You can read a great article by David Topfo at Georgetown about the responsibilities of the United States to separate civilian things from the military stuff, and the Defense Department is going down just the opposite direction on that. So it's interesting, and it's going to be difficult. But back on your first point, and by the way, the additional protocol to the Geneva Conventions 1 has a very clear statement about separating out the military and the civilian when feasible, and that's also tough in space. But anyway, I'll stop if someone else wants to go in. With respect to the first one, if you are over Ukraine and providing information that makes a direct contribution to military action by the location, use, purpose, or nature of your object, you have become a military objective and you can be targeted. So the companies are drawing a fine line right now, and their shareholders better be watching carefully, because these satellites are performing essentially military functions, even though they're not helping the Ukrainians just to help the Ukrainians. They're giving the information to everyone.
Other rejoinders from our other two presenters?
I can't remember the exact words, but I know that in the Secretary's Defense list of last year of various tenets, they include defending the national economy. So to the extent that the satellites are part of that, and we know we are dependent in many ways on satellite, all types of satellite communications and other things up there. They don't say how they're going to react, but the possibility of them, of our Defense Department taking an attack on a commercial satellite very seriously, and perhaps doing something about it is now within a stated objective.
With any bad luck at all, you will have case law pretty soon here.
Well, who knows? The Defense Department's list of what they'll do is not the White House's either, and there may be diplomatic and other reactions that would come first. So it doesn't necessarily mean that they shoot something down, we shoot something down.
Yes.
But it is in the national economy as a consideration is in that sentence.
Ms. Montgomery, closing thought? I think you're muted. There you go. Now you're shooting with all your someone.
I have nothing to add on those 2 questions.
Okay. So the last lecture, although not the last session, because we have a game and a closeout hot wash on the game, is going to focus on what many people argue is the major driver for space competition, and that is what China is up to. And so we'll have 2 speakers, we hope with slightly different views, but certainly will complement one another for our next lecture. And it promises to be pretty interesting because I've seen their presentations. These are people who know a great deal. I'm sure we can learn something from them. On that note, I don't know if any of you presenters want to hang around. You may not, but if any of you do, and there are students who have additional questions, we will certainly keep the channel open for that purpose. Otherwise, we will see all of you, I hope, next week.